Hi, it's Rory from Adero. The Merivale class action is now up and running. We are likely to have our first court date in the month of March before Justice Wigney of the Federal Court. There is nearly 8,000 group members in this class action. If you are employed by Merivale at any time during the 6 years prior to 24 December 2019, you too can register to join this class action following this email link. Our staff are available to speak with you should you have any further questions on the following number. I wanted to take some time to explain to each of you how you can participate in the class action. A class action concerns a group of people who participate in a single court case to resolve common questions of fact and law. For Merivale, there are two basic arguments that will be resolved by the court. The first argument is simple. It's a simple wage audit, just like that of any employer. We are instructed that there exists a group of salaried workers within the Merivale business that were paid to work in the order of 38 hours, but in fact were rostered and did work up to 55 hours per week with no additional pay. If these instructions are correct, we consider that the salaried workers, who likely exceed 1,500 people, will be entitled to back pay over the last 6 years with interest. We consider this portion of the claim represents a potential underpayment of between $12 million and $18 million. You will know whether you are part of this issue because you would have received a set annual salary and likely perform the role of a chef, manager, or related worker. The second issue involves the more complicated allegation that Merivale failed to pay overtime and penalty rates to their staff during the 6-year period. We know that nearly 8,000 workers for Merivale did not get paid overtime, night and weekend penalty rates according to Australia's modern award system. This occurred because Merivale was able to rely on a document called MRVL 2007 Collective Agreement. This document provided only limited penalty rates, but importantly was never intended to operate for a period of 11 years. It should have only operated from 5 years and ended in 2012 or 2013. Agreements such as the Merivale Agreement are known as zombie agreements because they were meant to have ended well before our claim period, which runs from 2013 to 2020. Our clients consider that the 2007 agreement was never validly approved in accordance with law, and that all workers, casual and salaried, are entitled to a back pay under minimum award entitlements for the last 6 years. Payments that would have been equal to any other worker performing an identical job in any other bar or kitchen. We consider that this class action will benefit up to 8,000 individuals for losses between $60 million and $75 million. This issue will involve detailed submissions of law and fact, which Mr. Boulos will serve as the lead representative to resolve. As group members, you are not required to give evidence or provide documents for this second issue. I know these issues can sound complicated, but they are in fact very simple matters that are resolved every day by employers and employees. You should stand up for your rights by registering for this class action. Please do get in contact with us.